My name is Paul Finkelman. I am a historian and I am currently the Chancellor of Gratz College in Greater Philadelphia. I also serve as a distinguished professor of history at Gratz. And the other important point for this meeting is that I was once the Baker and Hostetler visiting professor at Cleveland Marshall Law School, which is part of Cleveland State University. And so I had a very enjoyable year living in Cleveland.
Yes, and I'm sure they enjoyed having you at Marshall Law. So
I should also say that the following year I was a visiting professor at the University of Akron.
oh, wow.
So I have my Northern Ohio bona fides.
That's good. So today we're going to be discussing the primary points in your book, Supreme Injustice, Slavery in the Nation's Highest Court, which the library owns a copy of, so we can definitely check it out if we need to. So I think the first question I have is if you could just kind of maybe walk very quickly through how the Constitution kind of was set up to embrace slavery, or at least. Yeah.
Sure. And this is actually a very hard thing for many Americans to come to terms with, because we tend to think of the Constitution as almost a sacred document. And we don't like to have sacred documents impugned, or we don't like to see the stains on a sacred document. But what we really have to see the Constitution as is a document that is a framework for organizing a new government in the existing nation. The American nation begins, formally at least, in July of 1776, when the delegates from 13 entities, at that time still called colonies, but really beginning to call themselves states, declare that they are independent from the British government. And of course, we celebrate this as July 4th, 1776, the Declaration of Independence. And by the way, it's worth knowing that we're coming up on the 250th anniversary of the Declaration in just 5 years. Following the Declaration of Independence, the new independent states create a framework for government with something called the Articles of Confederation. And they create what is called a perpetual union, meaning that this will be a union of states that will exist forever. So when we think about the future of the United States and we think about the ultimate attempt by 11 states to secede and destroy the United States, it's important to understand that the United States begins before the revolution is over as a perpetual union. The Articles of Confederation are a relatively weak frame of government, but they work very well in doing what the rest of the world thought was impossible, which is for 13 small independent states to defeat the most powerful military force on the planet, the British Army and the British Navy. Now, we don't do it alone. And in fact, we do it with great help from the French, who at the Battle of Yorktown, among other things, prevent the British Navy from rescuing Lord Cornwallis because the French Navy gets there first. We also do it with the help of loans from France, from Holland, money from Tsarist Russia. We do it with volunteer officers coming from the German states, from what is today Poland, from France. Obviously, the famous people in this moment include Pulaski, Kosciuszko from Poland, Lafayette from France, General von Steuben from Germany, and many others as well. They're just the most well-known. But the United States defeats the British. The British come to the peace table. We sign a peace treaty between the United States of America and Great Britain, and we now have a country. It is 1783. The country is recovering from a war. The country has economic problems. It has a weak political infrastructure. There is no strong central government. There's a weak central government. And between 1783 and 1787, a group of far-sighted nationalists led by James Madison and Alexander Hamilton, who is now a Broadway star, but wasn't at the time, plan a convention to modify or to amend the Articles of Confederation. But their real goal is kind of replace the Articles as best they can with something that works better. They spend the summer of 1787 in Philadelphia, in the same building where the Declaration had been signed, debating the Constitution, debating what should go into it. And on September 17th, 1787, those who support the Constitution, those who are still left at the convention, sign the Constitution and send it off to the Congress, which is meeting in New York under the Articles of Confederation, with a directive that the Congress send it to the states and ask the states to elect special conventions in each state to ratify the Constitution. By the way, while we think of ratification of constitutions as common, until this time, there had been only one time in the history of the US when a constitution was ratified by the people, and that was in Massachusetts. All of the other state constitutions had simply been passed by the state legislatures and promulgated. People hadn't had a say in it. Now the people are going to have a say. So what is the document that sends out? Well, the document that has the framework that we are familiar with today: a president, a Senate, a House of Representatives, the obligation to appoint a court system, the Supreme Court and inferior courts. And of course, it's interesting to think about language because they use inferior not to mean that they are not important, but that they are below the Supreme Court. And we will have states, and the power to run the country is divided between the states and the national government, with some powers being solely the responsibility of the national government, some powers being solely in the hands of the state, and other powers being divided between the two. Now, to get to the question of slavery, at the convention, from the very first day that there is debate until the very last day when it is signed, the place of slavery in the new nation is debated, discussed, problematic, and almost derails the convention at various times. The big main issues are these. The new Constitution is going to have representation in Congress based on population. In the old Articles of Confederation, representation had been based on each state getting an equal vote in the Congress. Well, this didn't make a lot of sense. Tiny Delaware, tiny Rhode Island have the same vote as Virginia, which has about 40% of the entire US population. It's crazy. And so they're going to move towards population-based representation. And immediately the question comes up, do you count only the free population, or do you count people who are held in slavery? If you count all of the enslaved people, then Virginia and South Carolina and Maryland and North Carolina get many more representatives in Congress. If you don't count slaves, then Pennsylvania has the most representatives, because Pennsylvania has the largest free population, but 40% of the Virginia population are slaves. Massachusetts will be the third largest state. If you don't count slaves, New York is the fourth largest state. If you do count slaves, North Carolina is. So you can see that part of this is about political power. But underlying the issue of political power is a fundamental moral question. All of the southern states have been insisting since the beginning of the revolution that slaves are not considered people, but they are property. Because during the revolution, each state was obligated to support the national government by paying taxes and by supplying troops based on their population. And when this comes up in the Congress in 1775, the South Carolina delegates say, well, you can't count the slaves because they're property. And in fact, one Southern delegate says there's no more propriety in counting slaves than there would be in counting the sheep of New Hampshire. And Ben Franklin, who is smart and not easily intimidated by a blustering South Carolina slave owner, says, well, there's a big difference. Sheep will never make a revolution. In other words, slaves are a threat to the national security. Slaves are a threat to the society, not because they are Black people, but because they are held in slavery. If you free them, they're not a threat. And so Franklin says South Carolina should be paying taxes and providing troops based on its slaves because its slaves are actually a problem for the nation. Franklin loses. The Southern states don't have to count slaves. And that's the way it sits until the summer of 1787, when suddenly the slave states say, oh, wait a minute, slaves are people. If we're going to have population-based representation, you've got to count the slaves. Nobody calls them on this. Nobody says, well, 11 years ago, 12 years ago, you said just the opposite. Franklin had been in both places. He could have gone up and said, this is really interesting because you guys from the South have been telling us they're property, and now you want to count as people. Eventually, a compromise is reached. They will count the slaves, but not on a 100% basis, but on what's called a 3/5 basis. This is not a statement that Black people are 3/5 of a person. This is a statement that for purposes of political power, slaves will be counted on a 3/5 basis. By the way, what happens if the slaves are freed? Then they're counted as 100%. And one of the ironies of the American Civil War, which will happen many years later, is that after the war, the representation in the Southern states actually increases because they no longer have slaves. And so they count African Americans for full representation in the Congress. So you have to understand that what we're not talking about here is race discrimination. We are talking about political power. And in fact, to fully understand this, we need to remember that all of the Southern delegates say you should count the slaves fully for purposes of representation. And the Northerners say you shouldn't count them at all. Okay, that's the first big compromise. The next big compromise is over the African slave trade. And here you have a huge moral issue. The new Constitution is going to give the national government the power to regulate international trade with foreign countries. And the South Carolina delegates say, but you can't regulate the slave trade because we can't live without more slaves. We're going to import more slaves. We have to import more slaves. You can't regulate the slave trade. There is a 3-day debate on this. The debate is about morality. The debate includes many Northerners condemning the African slave trade. You oddly get a couple of Virginians condemning the African slave trade. In part, that's because Virginia has as many slaves as it needs, and it's actually selling excess slaves to South Carolina. But it is also the belief among some Virginians, like James Madison, that whether slavery is a good idea or not, and Madison owns 100 slaves, he's not about to free his slaves. But whether slavery is a good idea or a bad idea, importing more slaves is clearly a bad idea. Having more slaves isn't going to solve anything. And furthermore, the African slave trade is so horrible, with so many people dying, with the Africans being brutally uprooted from their homeland and chained up and shipped to America, that even if you think slavery is good, you shouldn't be importing more slaves from America. So there's this debate. And in the end, the compromise is that the slave trade will exist for 20 more years till 1808. And then Congress may, but does not have to, stop the African slave trade. A third compromise concerns the Electoral College. You all remember the Electoral College. That's that weird thing that comes from the deep lagoon somewhere and comes to haunt us every 4 years. Because the Electoral College says you don't elect the president with a popular vote. You elect the president with this electoral vote. And what is the electoral vote based on? Well, it's based on the number of representatives you have in Congress, which is 2 senators plus your members of the House. And the House allocation is based on the 3/5 votes. At the convention, James Madison, who's often called the father of the Constitution, says that the most appropriate thing would be to elect the president with the people voting for the president. But he says there's a big problem here. We won't get any votes from our slaves. And therefore, we're at a disadvantage. One of the other delegates, in a footnote to his private notes, says that the problem is Virginia won't be able to elect their people president if they don't count slaves who are electing the president. So again, we create the Electoral College, which gives the slave states extra votes for the presidency, not based on voters, but simply based on the property of the South. Maybe New Hampshire should have gotten extra electors for its sheep. That would have been the other way of doing it. There are a couple of presidential elections, the election of 1800, the election of 1836, where had it not been for the Electoral College, a different candidate would have won. Thomas Jefferson would not have won the election in 1800, but for the electors created by counting slaves for purposes of representation and purposes of the Electoral College. It's worth remembering at the time, Thomas Jefferson owns 200 slaves, including some of his own children who he had with his slave, Sally Hemings. He's running against John Adams, who has never owned a slave and despises slavery. Finally, there's something called the Fugitive Slave Law, which says that Southerners have a right to go into the North and grab their fugitive slaves and bring them back to the South. That will have a huge impact in Ohio. There will be many Ohioans who will be sued or prosecuted and sent to jail for helping fugitive slaves in the 1840s and 50s. In fact, one of the most famous events of the 1850s starts in Oberlin, Ohio, when a man is seized as a fugitive slave and taken to Wellington, Ohio, which is 10 miles away, where they're going to put him on a train and send him to Cincinnati and then take him to Kentucky. And a huge number of people from Oberlin, including most of the students and faculty at Oberlin College, get on their horses and ride to Wellington, Ohio, rescue this man. And later, a whole slew of them are arrested and thrown in jail and tried in Cleveland in 1858 because of this rescue. So these are the big issues. There are other slavery issues. One odd one is that the U.S. is not allowed to tax exports. Why can't we tax exports? Who cares, right? Well, here's why it matters and why we can't do it. We can't do it because the main export in the country was tobacco in 1787. Cotton isn't yet a cash crop. And the Southerners say you can't tax exports because that's a way of indirectly taxing slavery. It's all about protecting slavery. It's all about protecting their investment in buying and selling human beings and treating them like property. And why might you want to tax exports? Because if you are a country which produces something that nobody else can produce as well, then taxing exports is a way to relieve the taxpayers by getting people from other countries to pay taxes to you. And there are lots of things the United States has always produced cheaper or better or only produced than other countries. If you buy oil from Saudi Arabia, you're paying a tax to the Saudi Arabian government. But now the United States, which actually has a small oil surplus, can't tax the oil going to some other country. So these are the things that lead to the Constitution protecting slavery. That's a very long answer to a very short question. Sorry.
No, I think that's perfect. And the only other thing that I learned from your reading your book was the militia aspect of it, where the North was going to have to help.
Right. So again, one of the other clause, I said there are many other clauses. One of the clauses is a clause which says that the United States government will suppress domestic insurrections. And the militia can be used to suppress a domestic insurrection. Well, what's a domestic insurrection? If you're a slave owner, it's only one thing, it's a slave rebellion. Again, and this is where how we learn our history alters our understanding of history. So when I went to school, I was told that one of the reason for the domestic insurrections clause and the militia clause was because of something called Shays' Rebellion. Shays' Rebellion had been a rebellion of taxpayers in Massachusetts who had marched on the courts to close down the courts because they couldn't afford to pay their taxes because they were short of money. And so I was taught, well, the domestic insurrections clause was something that the Northerners wanted to protect themselves from taxpayer revolt. Not true. Something the Southerners wanted. And they want it because they fear their own slaves. And by the way, it's used that way. In 1831, there's a big slave rebellion in Virginia called the Nat Turner Rebellion. And the US Navy is sent up the James River to help suppress the slave rebellion. And militia troops from North Carolina are sent into Virginia to help suppress the rebellion. And the Virginia militia is called up to suppress it. And then in 1859, there's the raid on Harper's Ferry by John Brown, who, by the way, is from Ohio. John Brown lives in Hudson, Ohio. And John Brown raids the U.S. arsenal at Harper's Ferry. And who saves the day? Not the Virginia militia, but the U.S. Army that comes in and suppresses the insurrection. So the South relies on Northerners to save them from their own slaves. And by the way, some Northerners opposed the Constitution because of this clause and the slave trade clause.
Yeah, it's very interesting how slavery was definitely on the minds of everyone while they were crafting the Constitution and very much a part of the debate. But I don't know if you have time or the interest to maybe talk a little bit more about the fugitive slave laws and this court case, Prigg versus PA.
Okay, so let me talk about it quickly.
Yes.
Let me read the Constitution clause, because one other thing to note about the Constitution is the delegates in Philadelphia are careful not to use the word slave in the final document, in the final US Constitution. They are careful not to use the word slave. They use it in ways that hide what they're talking about. So Article 4 of the Constitution says, no person held to service or labor in one state under the laws thereof, escaping into another, shall in consequence of any law or regulation therein be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. This is a very roundabout, backwards way of saying that if a person held to service or labor, that is a slave under the laws of Virginia, runs into Ohio, Ohio cannot free that person, but Ohio must deliver that person up to that runaway slave, that freedom-seeking African American must deliver that person up to the Virginian who claims that person as a slave. And in 1793, Congress passes a law to facilitate this, which includes the ability of Southerners to sue any Northerner who helps their slaves escape or helps their slaves once they've escaped. And furthermore, allows for a $500 penalty in addition to the suit, and provides for judges at the state and federal level to enforce these laws. There are a lot of cases in Ohio about this, as you can imagine, because Ohio has a very long border with Virginia and with Kentucky, both of which are slave states. And remember, West Virginia in those days was part of Virginia. And Ohio is famous for being a center of what became known as the Underground Railroad. That is a loose, almost non-organization, but a loose connection of people who would help slaves who escaped into Ohio. And for those of you who have the time, it's always worth going down to Cincinnati to the National Freedom Center and Underground Railroad Museum, because it's really a very spectacular museum. And it's in Cincinnati because Cincinnati was seen as the gateway to freedom to slaves who escaped from Kentucky and from Virginia and from other places in the South. You go from Tennessee to Kentucky to Cincinnati. Okay, so the northern states are worried that under this law, Southerners will just grab any black they can find and say, this is my slave. Remember, there's no photographs, there's no fingerprinting, there's no DNA. It's this white man's word against some black person, a child perhaps, somebody who might not have very much education or no education at all. And a Southerner comes in and says, this is my slave John and his wife Mary and their 3 kids, and I want them to come back with me. I'm grabbing them. And as a result, most of the northern states pass what are called personal liberty laws, designed to make sure that there's a fair trial. These northern states are not opposed to returning a runaway slave. They just want to make sure that they're not helping somebody kidnap a free person. By the 1820s, slavery has been completely abolished in much of the North. Ohio becomes a state in 1903, and there is no slavery in Ohio. New York had slavery, but in 1827, it frees all the remaining slaves in the state are free. Pennsylvania, New York, Rhode Island, Connecticut, New Jersey had all passed laws to gradually end slavery by making sure that the children of all slaves were born free, and therefore slavery would literally die out. So these states are trying to protect their free black neighbors from being kidnapped. And in 1837, a group of 4 men from Pennsylvania go into, I'm sorry, a group of 4 men from Maryland go into Pennsylvania. They seize a woman named Margaret Morgan and her children and her husband. They bring them before a justice of the peace, who after talking to them concludes they're not slaves, they're free people, and says you can't take them back. And the Marylanders say fine, and then they proceed to kidnap Margaret and her children, but not her husband, because her husband had been born free in Pennsylvania, and even these guys weren't going to grab him. But they grab Margaret, they grab her children, they bring them to Maryland. One of these men, a man named Edward Prigg, is eventually indicted for kidnapping. He's tried in Pennsylvania, he's convicted of kidnapping, and it is appealed to the US Supreme Court. And in a remarkable decision in 1842, written by Justice Joseph Story, who was from Massachusetts and who had once been a strong opponent of slavery, Story writes that no state can interfere in the return of a fugitive slave. No state can protect its free black population from kidnapping. That the 1793 Fugitive Slave Law is completely constitutional. And furthermore, if a slave owner sees a runaway slave in the North, he can grab that slave and bring the slave back to the South without any court hearing at all. He can grab anybody and grab. It's an open invitation for him. And that's Story's decision. And it's shocking because Story had begun his life as an opponent of slavery. And he ends writing this unbelievably pro-slavery decision, essentially saying that it's okay to kidnap Black people wherever you find them and bring them back to the South. In response to this, most of the northern states passed laws prohibiting their state officials from participating in the return of fugitive slaves, prohibiting them from using jails to house fugitive slaves. And that creates a problem for Southerners because it's one thing to cross into Cincinnati, grab somebody, bring them back across the river. It's quite another to go up to Auburn. That's a long way. That's a lot of travel. And you're going to run into lots of people in Ohio who don't like slavery. So you need police protection. You need guys with guns to protect you if you're going to take Black people out of the North. And so in 1850, Congress passes a new fugitive slave law, which creates the first federal law enforcement in the United States at a national level. And one of the ironies of American history is that Southerners secede because they claim that federal government is not protecting their rights. And they talk about states' rights. But in fact, they're not interested in states' rights because states' rights would be the right of Ohio to prevent its sheriffs from having to hunt down runaway slaves. What they want, in fact, is to destroy states' rights and impose a national law all over the North to help them return fugitive slaves. We could talk about fugitive slave laws in Ohio for days. It's a big topic.
Right, and that's it's a great summary. I think it hit all the points I had noted on my, the goal to nationalize the fugitive slave rendition was Story's decision.
Yes, Story nationalizes slavery. Story essentially says that under the Constitution, there is a presumption that all Black people are slaves. All Black people in the North are fugitive slaves, even though by this time there are more than 30,000 Blacks in Ohio who are free. There are more than that in Pennsylvania and New York. And Story is putting all of them at risk.
Right. And the point you make too in the book is all the three justices that you look at all kind of have to do some pretty big legal acrobatics to get to the point of defending slavery.
Well, they're happy to do it though. Story may have been unhappy to do it, but he doesn't. Now, remember, we started with the pro-slavery aspects of the Constitution. So the Constitution says you can retrieve your fugitive slave. But the Constitution also says that all people are entitled to a jury trial. The Constitution also says that you can have a lawyer. The Constitution doesn't say that you can get your fugitive slave without having a judge say, yes, not only do you own a fugitive slave, but this person is your fugitive slave. So it's what we call due process clause, the fair administration of justice. And that is what is destroyed by the Supreme Court. And Story writes, if it were not for the Dred Scott decision, which happens 15 years later, we would remember Prigg as the most pro-slavery decision that the Supreme Court has ever issued. I guess for Story's reputation, he's lucky that he passes away soon and 20 comes along and writes Dred Scott.
Yeah, and briefly, I think everyone's pretty familiar with Dred Scott, but maybe you could explain kind of less the details and more why it's what it did
Okay,
legally. Yeah.
all right. So Dred Scott, first of all, let me tell you who Dred Scott is. Dred Scott is a slave who was owned by a slave owner in Missouri. The slave owner in Missouri takes Dred Scott to Illinois because the slave owner is an army captain. He's a doctor in the army, and he's stationed in what is today Rock Island, Illinois, at a fort in the Mississippi River. And he takes Dred Scott to Illinois. Illinois is a free state. There's no slavery in Illinois. Keeps Dred Scott there about 2 years. Then he gets transferred to what in those days is called the Wisconsin Territory and is today the state of Minnesota. Gets transferred to St. Paul, Minnesota, to something called Fort Snelling. And he keeps Dred Scott in Fort Snelling. Then he goes down to Louisiana because he's transferred to Louisiana. When he's there, he gets married. He writes to friends who, by the way, he rents Dred Scott out when he goes down to Louisiana. And he rents him to other soldiers in Fort Snelling. Then he has Dred Scott sent down to Louisiana. Then they all go back to Minnesota, live there for a while. One of Dred Scott's daughters, by this time Dred Scott has a wife, although they're not legally married because slaves can't be legally married, but he has a wife, he has a child. His second child is born on a riverboat on the Mississippi River in between the free state of Illinois and the free territory of Iowa. So the child is born in free territory, lives in Minnesota for it. Then Dr. Emerson leaves the army, moves to St. Louis, takes Dred Scott and his family back to St. Louis. He passes away. His wife now owns Dred Scott and Harriet Scott and their 2 children. Dred Scott, in the meantime, has run into some white men who had been the sons of his first owner. And they had been his playmates when they were growing up. Because when he was a young boy, these guys had been his playmates, even though they were the owner, he was owned by their father. And these men are now successful businessmen. And they say, hey, we'll help you get free. And so they offer to loan him money to buy his freedom from Mrs. Emerson, who owns him. But she refuses to sell him. And so he sues, gets a lawyer and he sues. And the basis of the suit is this. I lived in Illinois, which is a free state. I lived in Minnesota, which is a territory made free by the Missouri Compromise of 1820. Therefore, under federal law, I'm free, and under state law, I'm free. Therefore, I'm free. And a jury in Missouri declares him free. 12 white men say, yeah, you're free. You lived in a free place, you're free. And he is going to be free, except Mrs. Emerson appeals. Missouri Supreme Court reverses the decision. And then, odd twist of fate happens. Mrs. Emerson leaves Missouri, moves to Massachusetts, and sells Dred Scott to her brother, a man named John Sanford. John Sanford is a Missouri businessman, but he is currently living in New York. And this is where it gets complicated, so I would tell everybody to fasten your seatbelt to figure this one out. Okay. Under the US Constitution, a citizen from one state can sue a citizen from another state in a US court. So Dred Scott has lost in the Missouri courts, but now he has a lawyer who goes to the US federal court and sues John Sanford, saying, I am a free person in Missouri and I'm suing you who live in New York. And it goes all the way to the Supreme Court. And the Supreme Court basically says 2 things. Well, I'm going to fix this. Supreme Court says three things. Two of them really matter. The one that doesn't matter was to say that we're going to follow Missouri law. And so if he's a slave under Missouri law, if the court had shut up with that, we wouldn't be talking about the case. We wouldn't care. It would just be one more case in which an unfortunate slave family wouldn't get their freedom. But Chief Justice Taney, who is vigorously pro-slavery, obsessed with slavery, he comes up with two other theories. The first theory is that no Black person, whether free or a slave, can ever sue in federal court. And so he says that Dred Scott cannot sue in federal court because he is Black, and Blacks have no rights under the US Constitution. And so what he basically says is that you got to have a right to be in federal court. You can never sue in federal court. And he then goes on to say that, and I'm going to quote from the opinion, that Black people are not citizens under the Constitution, and they can claim none of the rights and privileges that belong to citizens of the Constitution, and that they only have such rights or privileges as those, quote, who held the power and the government might choose to grant them. And he basically says that Black people have no rights that a white person needs to respect under the US Constitution. And this becomes, of course, the most famous or infamous or hated Supreme Court decision because it is so grotesquely racist that they have no rights that the white man needs to respect. Now, having said that, he should have ended the case, because what he said is, you have no right to be in federal court. Therefore, he should have said this case is over because you can't sue in the case. But he then goes on to say, Dred Scott claims to be free under the Missouri Compromise. And this is a compromise passed by Congress in 1820, which said that the federal territory north of Missouri, the present day states of Iowa and Minnesota and Kansas and Nebraska and the Dakotas, that they would be free. And Chief Justice Taney says that law is unconstitutional because Congress has no right to regulate the federal territories, and that slavery is a specially protected property, and therefore slave owners have a right to take their property anywhere they want. So that is why we remember Dred Scott. Now, a couple of funny things about all this. Maybe not funny, but odd and worth knowing. Some people who like Taney for other reasons have always said, well, this was the decision of a very old man. Taney is in his 70s when he writes this. He's old. We shouldn't measure his value as a justice by this one case. Yeah, he overstated this thing, but let's forgive him this. But what I point out in this book is that 25 years earlier, in 1832, when Taney had been Attorney General, he said exactly the same thing when he was a young man, when he was at the height of his vigor, his vitality, his mental powers. He said, Blacks have no rights under the Constitution. He had always believed that. So this is not something he made up late. This is something that he always wanted to do because Taney hated the idea of free Black people living in the United States. And he did not want to give them any rights. They have no rights that have to be respected. So that's Chief Justice Taney. In fugitive slave cases, he does the same thing. He always finds a way to protect slave owners. He always opposes freedom, even when slaves had a legal, legitimate reason to be free.
Yeah, and you make the point too that you think he was actually hoping to like finally solve this slave issue.
Yeah. So Tawny essentially thinks that he can solve the problem of slavery by essentially telling the North, you have to shut up and live with it. You can't oppose slavery in the territory. You can't oppose new states coming into the Union with slavery. You have to allow slavery to spread everywhere. And the most articulate critic of Dred Scott, a man who becomes famous for criticizing Dred Scott brilliantly, is a mostly unknown lawyer from Illinois named Abe Lincoln. And Lincoln gives speeches all over the United States in 1857, 58, 59, and that gets him nominated for the presidency in 1860.
And it was interesting too that you mentioned that Tawny drafted an opinion striking down the Emancipation Proclamation.
Yes.
Didn't get to rule on it, but he had it ready to go.
He's so pro-slavery that when Lincoln declares that the slaves owned by the seceding Confederates, people who've committed treason against the United States, can be freed because it is necessary to win the war, Tawny drafts an opinion saying this is unconstitutional. He's opposed to black freedom at all times. He's pro-slavery at all times.
Well, one of you kind of end the book with this quote that we'll paraphrase a little bit, but the fact is that the South, who won virtually everything from the court, was never enough to satisfy the demands of the slaveocracy. And that when Lincoln is elected, they basically say they cannot tolerate losing.
Yeah.
And that's why.
The Constitution creates the expectation, and the Supreme Court creates the expectation, that slavery always wins, freedom always loses, black people always lose, and there will be for slavery forever. And when Lincoln is elected, he's the first president who has articulated an absolute hatred of slavery. There were other presidents, John Adams, John Quincy Adams, certainly, who hated slavery. But most of the presidents from Washington to Lincoln had been slave owners. Most of them had been Southerners. And there were even two Northerners, James Buchanan and Martin Van Buren, who had been slave owners in Pennsylvania and New York early on in their lives. So the Ohio president, William Henry Harrison, he was a slave owner from Virginia. He still owns slaves in Virginia. His family did. So slavery had run the country. And when you get the first president elected who says slavery is wrong, Lincoln famously says in a letter, if slavery is not wrong, nothing is wrong. And he says that slavery should be put on the road of ultimate extinction. As president, he doesn't have the power to end slavery. He says, I have no power to touch slavery where it is, but I'm not going to let it spread to new states. I'm not going to let it expand. And that's enough for 11 Southern states to make war on the United States. And by the way, keep in mind that the leaders of the Confederacy had all been political leaders of the United States. Jefferson Davis had been Secretary of War. He can hardly say that the South doesn't have power in the government. But they were the ultimate sore losers. They lost an election and they said, rather than accept the outcome of an election, we're leaving the country. We don't want to be part of the country because we didn't win the election. They're crybabies, but their being crybabies kills 650,000 or so American people and destroys vast amounts of property and leaves many hundreds of thousands of men wounded and damaged because they could not accept the outcome of the democratic election.
Maybe you could speak a little bit about how in Cleveland we have the John Marshall School of Law, and you've been instrumental in getting his name removed from Chicago, correct?
Okay, so let me talk about the third justice
Yes, please do.
trilogy, and that's John Marshall. When I started this book, Supreme Injustice, I really didn't know what I was going to say about John Marshall. I read some biographies of him, and all the biographies said the same thing. He owned a dozen house servants, they called them, in Richmond. He wasn't really interested in slavery. He didn't make money on slavery. He didn't like slavery. He heard very few cases involving slavery. And for the most part, he did what he had to do to protect the country, but he wasn't pro-slavery anyway. And that's what I thought. And as I was writing the book, I discovered that Marshall had offered to free one slave when he died, but that slave never got to be free. And I read a biography of Marshall in which he said, in which quoted the will, and the will said, "It is my desire that my faithful slave Robin be free, if he desires." He actually called him my faithful servant. He didn't call him slave. And I thought, well, why wouldn't Robin be free? So I went and I read the will. And I discovered that the conditions for Robin becoming free were so difficult that Robin couldn't actually accept freedom. But then I read the rest of the will and I was shocked, because one clause of the will says, "I give my slaves at my plantation at Chickahominy," which is a river outside of Richmond, "to my nephew. I give the land and the slaves that my son John lives on in Fauquier County to him. I give the land and the slaves that my son Edward lives on to my son Edward." And I'm thinking, well, this is a lot more than a dozen slaves. And I worked with a very good person who is expert in looking at census records and tax records. And we determined that there were 61 slaves at Chickahominy. His son John had almost 40 slaves. His son Edward had about 25 slaves. And it turns out that John Marshall has land all over Virginia. I exaggerate, he has land in 3 or 4 counties of Virginia with slaves on the land. And then I found his notebooks from when he was a young man, where he describes buying the slaves, and he buys one slave, he buys another slave, he goes on a trip, he comes back with a couple more slaves. Turns out John Marshall's buying slaves his whole life. He didn't inherit them the way his cousin Thomas Jefferson did. Jefferson inherits hundreds of slaves. Marshall buys them. And he probably owned at least 250 or 300 slaves during his lifetime. And he is a vigorous purchaser of slaves. And when one of his sons dies and leaves a debt, rather than paying the debt with ready cash or selling land or selling stock, Marshall's a very wealthy man, he sells slaves. And it's important for people to understand that selling a slave is a horrible event for the slave. They're separated from their family, from your husband, from your wife, from your children, from your parents. You never see anybody again. Excuse me. It's not like you can go on FaceTime and visit your mother or your child. Marshall has no care at all for the lives of these people. They are simply property. And I was shocked by this because it's not what everybody says. And then I looked at his cases And I discovered that, in fact, he heard lots of cases. While Marshall's Chief Justice, the court heard 14 cases in which the freedom of a slave was at issue. And in these cases, you had slaves that had a claim to be free. They could prove their mother was free when they were born, and therefore they couldn't have been born a slave. They could prove that they had been taken to a free jurisdiction, and therefore they became free, like Dred Scott claimed. Some of them claimed that they had been taken to Washington, D.C. and not properly registered. If you moved to Washington, you had to register the slave. And because the registration was a failure, they didn't properly register them, they were immediately free. In a number of these cases, juries in Washington declared slaves to be free. Of the 14 cases, Marshall decided 7 of them, and in every one of them, the slaves lose. In 6 of the other cases decided by other justices, the slaves won. And then there was one case decided by a South Carolina justice where the slave lost. So the bottom line is, whenever John Marshall heard a case involving Black freedom and decided it, the slave lost. When he couldn't decide it and somebody else got outvoted, then he just shut up because dissents were very rare. The African slave trade is another big issue because Congress does ban the African slave trade, and it's illegal for Americans to be involved in the African slave trade. But whenever Marshall decides a case involving the illegal trade, the trader wins. These laws find you, they could send you to jail. You could be literally, you could be executed for slave trading. Marshall never upholds the conviction of a slave trade. And when slaves are illegally brought into the United States, he doesn't say, well, they're free because they couldn't be brought here. He finds a way to make many of them slaves. So it turns out that John Marshall is overwhelmingly pro-slavery. And it turns out that in his non-court public life, he is a strong advocate of forcing all Blacks in the US who are not slaves to leave the country and go to Africa. And at one point, he petitions the Virginia legislature to pay to remove every Black from Virginia who's willing to go to Africa. And he says in this petition that half the free Blacks in Richmond are criminals. Now, he knows better. He lives in Richmond. He's a judge. But he is making this strong anti-Black, pro-slavery argument over and over again. And why is he doing it? Because he owns hundreds of people, because he buys and sells them, because that's what makes him rich that much. That's what makes his family happy. So it's really a shock. Now, after this was published, it turns out that there are 3 law schools in the United States named for John Marshall. One in Atlanta, one in Chicago, one in Cleveland Marshall Law School. The people at Chicago had a long internal debate. They asked for my input. I said, look, I can't tell you what to do. You change the name of your law school if you want to change it. But whether you change it or not, this is what you have to know about John Marshall. Cleveland Marshall Law School had a symposium last year. I was on it on Zoom, where we talked about John Marshall. I don't know what Cleveland Marshall is going to do. I've had, very nice conversations with some of the faculty, with the dean. I taught there once. A great school. I love the school. Great friends who teach there. It's a great place. But whether Cleveland Marshall changes its name, I think it does have to use this as a teaching moment to say, we honor the great decisions of Chief Justice Marshall, but we do not honor the fact that he trades in human flesh, that he buys and sells people, and that all of his decisions involving slavery support slavery, and he never lifts his pinky finger to help end slavery, to help solve America's most horrible and difficult problem. So that's John Marshall.
Well, yeah, and I think it speaks to a lot of the quote unquote great men of the time who were compromised in some regard by slavery.
Well, so the defense of Marshall is he's just like everybody else, right?
Right.
But do we honor people because they're just like anybody else?
Right.
We honor people because they're better than everybody else. But the fact is that there are people who are better. Marshall writes a biography of George Washington. He is the first person to write a serious biography of Washington. He served on Washington in the Revolution. He served at Valley Forge. He's a captain in the Continental Army. He loves George Washington. George Washington comes back from the Revolution a changed man. He had Black soldiers who fought valiantly. He comes back from the Revolution and he says a couple of things. One, he says is, I'm going to free my slaves. And two, he says, I will never buy and sell slaves again. He says, I do not take men to market like cattle. John Marshall is at the market all the time, buying and selling people. John Marshall is not George Washington. In his will, George Washington not only frees all of his slaves, but he provides land for them, and so we'll have a way of making a living. Marshall says he'd like to free one of his slaves, but doesn't even do that. There's a man named Edward Coles, who is James Madison's secretary, which would be today like the president's chief of staff, right? Coles inherits about 20 odd slaves, 20 or so slaves, 25 slaves. That's a lot of money. No, worth $1 million. Coles takes all of his slaves to Illinois. He buys land for them and he frees them. Marshall doesn't do anything with it. In 1782, Virginia passes a law allowing people to free their slaves, and the former slaves can stay in Virginia. So you can free somebody and they don't have to run away, leave everybody they knew. The free Black population in Virginia goes from 2,000 to about 30,000 between 1780 and 1810. They changed the law in 1860. This huge growth is not based on free Black people having lots of children. That would have been impossible. It's based on the fact that Southern slave owners in Virginia are voluntarily freeing their slaves. They're saying, we don't believe that it's proper to own another human being. We will take a financial hit. We will free these people because we do not believe it's moral, it's just. In the 1790s, a very wealthy slave owner named Robert Carter, who is known as Chancellor Carter. There's so many Robert Carters, they all have nicknames. Robert Carter frees about 500 slaves. Comes back from church one day and says, I can't go to church and pray and think I'm going to heaven and own slaves. And he starts freeing his slaves. Takes him a couple of years, he has so many. So there are lots of people in Virginia and some in South Carolina and some in North Carolina who free their slaves. In New York, a law is passed that will gradually end slavery. The children of all slaves will be born free, which means gradually you're going to lose your slaves. You're not going to have new slaves. The man who signs that statute, the governor of New York, is John Jay, the diplomat, the former Supreme Court justice. John Jay is a slave owner. He was a wealthy man in New York. Most wealthy men in New York owned slaves. He owned slaves. He signs the law to end slavery in New York. He signs the law to get rid of something that he has a personal investment in. So you can't say that John Marshall is just like everybody else, and therefore we should cut him some slack because there are important people, George Washington, John Jay, Edward Coles, Robert Carter, who aren't just like anybody else. There's a congressman from Virginia named John Randolph who owns scores of slaves, takes them all to Ohio and frees them. So you just can't say, well, people have told me, well, you're trying to impose your 21st century values on John Marshall. My answer is no. I'm trying to impose the values of the Declaration of Independence of the American Revolution on John Marshall. I'm trying to impose the values of his world. By the way, the very fact that he is so secretive about all of his violence and his slaves, the very fact that he is not remembered as being a slave because he has his dozen slaves in Richmond, which people who would visit him in Richmond would see. But he's got a plantation with 60-something slaves 10 miles away. He's got other plantations with slaves. The fact that he structures his life that way, I think, suggests that he knows that what he's doing is really wrong, but it doesn't stop him from doing it. And so, yeah, I think he lives a dishonorable life. Furthermore, when you read his decisions, they're sometimes shocking. There's one case where it involves the law requiring that you register a slave when you come into Washington, D.C. if you're going to live there. And a slave is declared free because his owner didn't register. And Marshall writes in the opinion, the statute is ambiguous and it could be decided one way or the other without doing any damage to the statute. And when I read that, I thought, aha, he's going to free a slave. And then in the next sentence, he says, but the evidence is that the slave should remain a slave. He doesn't want to free somebody. And why doesn't he want to free somebody? Because he's busy buying so many slaves himself. He sympathizes with the slave war. There's another case where a slave is born in Maryland, bought by somebody who moves to DC and is living in DC. The Maryland courts declare that the mother of this slave was never legally a slave, that she was always a free person. And thus, when he was born free. This woman has a bunch of children. All of the children in Maryland were immediately free under Maryland law. In DC, the DC court says, we respect the Maryland decision that this man's mother was free, always free. He is free. We're letting him go. And Marshall reverses that. I think Marshall reverses that because he personally could see himself buying a slave and then finding out that, oh, he wasn't really a slave. You know, if I buy a car from somebody and it turns out the car was stolen, I don't get to keep the car. But for Marshall, if you bought a slave from somebody and the person was actually free and therefore kidnapped, you get to keep the kidnapped person. That's who Marshall is. And for all of his great decisions, and he was a great justice, and he wrote many important decisions. For all of his great decisions, it's one thing to teach him. You know, somebody said, is this all about cancel culture? And I kind of laughed and said, look, I taught constitutional law for 20 years. You can't cancel John Marshall. You know, in most con law cases, the first case you read is Marbury versus Madison, opinion written by John Marshall. I would assign 4 or 5 Marshall opinions in one semester, probably more than any other justice. It's not about canceling John Marshall, but it's also not necessarily about honoring.